101.1 FM. My name is Ruth Usman, and we sincerely apologize for that break in transmission. It was due to some technical issues, but gladly, all that has been sorted out, and we are here. And we are about to have a conversation with our friends from WAMASN, that is Waste Management Society of Nigeria. So I would allow my guests to introduce themselves. Good morning to you.
Good morning. My name is Kiton Oluwagboye. And
good morning, Nigeria. My name is Charles Chukwuzo.
Okay, you're welcome. As always, you have about 5 minutes to talk to us about the environment, how we dispose of our waste, and so many other things. So let's listen to what information you have for us today.
Well, thank you once again. This morning we want to discuss on the World Environment Day that was celebrated yesterday in Nigeria and all over the world. Organizations and ministries had a good day to think about beat plastic pollution, our responsibilities. So that's what we just want to reinforce today, that we need to beat plastic pollution and what's our duty of care as individuals, as corporate organizations, and as government. And our view as WAMASN is that if we can do 3 things out of many that can be done, we will have made a difference. What are those 3 things that we can do as individuals? The first and foremost thing is that as you generate your waste, sort the waste. Sort those ones that are degradable and put those ones that are recyclable. The things that are degradable are those things that go bad. The things that are recyclable are those things that can be recycled. So separate them. If you have done that, you have done a good civic duty as a citizen. And then beyond that, it's for you to reuse or to reduce the waste you generate. If you're able to carry all the shopping bags you collect from the market and take it back, the ones you collect from the shopping mall, pack them together, take it back to them and ask for a discount for whatever you buy next, because all the shopping malls, all those producing plastics have a responsibility to take back. So since they have a responsibility under the national law called extended producers responsibility to take back their plastics, you as a citizen should demand for that right. You have the right to just buy the things you want to buy and they put it in the nylon bag. When they have given it to you, put them together and then return back to them, collect your discount. From the garments and all the dry cleaner, the same, all their hangers and all the nylon, return back and get a discount. Demand for EPR, because
this is, you're saying it happens like there's provision for it in Nigeria where you
the law is there.
Okay.
I do it for the dry cleaner myself. I return back, and because of that I have gone beyond 10%, 20% discount, and I'm now earning 25% discount for my dry clean clothes, simply because I return his hanger and the nylon back to him. He's the one who produced it. I don't need them, so give him and he gives me discount. It's a collective responsibility to beat plastic pollution in Nigeria. We cannot leave it all to government. Government has made the law. Because they have made the law, we as individuals and corporate organizations need to do our own. Our own is to separate waste, sort out waste, segregate waste, reduce waste, recycle waste. We can only support recycling in Nigeria when we sort out the waste. We can only support the law that has been in existence since 2009 when we demand that you, who is the producer of the plastic, take your plastic and give me a discount for it or any other thing of value. And while that is just individual and corporate responsibility, the next thing required for government, they have about 6 options, but I will talk only about 3 today. One option is they have made the law for recycling, to support recycling, a very good law. They have another option to tax everybody. By that EPR law, it's a tactical way in which tax will come. There's nothing free anywhere. So since those people who are producing the plastic will have to do extended producer responsibility, take back, they will tax us as consumers. However, so it's inherent in the law. Then they have the opportunity as government to ban plastic or to say we'll change from the current type of plastic to a biodegradable one. As Wamasin, we believe the recycling is key because it will solve 50% of the environment. If we go in the way of biodegradable plastics come from corn, potato, soybean. How much of corn do we even have to eat in Nigeria? How much of potato do we produce in Nigeria to the extent we now want to start using it for plastic? When the industry currently in Nigeria, the fact says that we are getting our plastic 30% from LMA petrochemical. The remaining 70% is imported. And now we are having investment of Quantum and Dangote coming into the petrochemical. So we will not support our own economy if we, at this stage in Nigeria, go for biodegradable plastics. Because 30%, if we change our plastic today to all biodegradable, we will have only solved 30% of the problem of plastic pollution in our environment. But if we manage the plastic that we have now, we will solve 50% of it. So in simple arithmetic, 50% when we manage the environment by recycling and with awareness for people, with the law we have on ground, and then in future go for biodegradable plastics, which is 30%, we have only managed 80%. The remaining 20% will still have to be dealt with by disposal.
Okay, so let's take a moment and listen to Mr. Charles. Mr. Charles will be asking the question for today. All right, so let's have it.
Yeah, looking at the science, recycle science. Can we view the recycle science?
Yeah.
So today when we leave, let's check our plastic bottles and see this recycle science, because this is where our question is going to come from.
Oh, okay. For every plastic that we
Yes,
we should look out for this science.
Yeah, look at this science.
Okay.
This is where our questions today is going to come from.
And tell us the number.
So the question for today is, state the recycle sign number on the plastic bottle water. I take it again.
Yeah.
The question for today says, state the recycle sign number on the plastic bottle water. Thank you.
All right. The number to send that answer or your answer to is 081 4336 1507. That is 081 4336 1507. Our friends from Wilmington are always here with us every Wednesday in the X-ray hour. So in case you're wondering, they will be here, God willing, come next Wednesday with another angle to how we can best dispose of our waste. Many thanks for your being here.
Thank you.
And thanks to you, our listener. Stay with us right here on Human Rights Radio 101.1 FM. I'll be back in the 10 o'clock hour for Probono Chambers. My name is Ruth Usman.
Beyond Radio 101.1 Human Rights Radio.
I know you're gonna dig this.
Redefining broadcasting.
Human Rights Radio on 101.1 FM.
Anywhere you go, wherever you are, we are your family. Human Rights Radio 101.1, redefining broadcasting. Anywhere you go, wherever you are, we are your family. Human Rights Radio 101.1, redefining broadcasting.
Join our diverse team of legal experts as we provide education and guidance to you, our listeners, on a broad array of issues raised by the modern legal landscape, absolutely free on Probono Chambers, airing on Human Rights Radio 101.1 FM, redefining broadcasting.
Human Rights Radio.
Good morning. Thank you for joining us. 6 minutes into the 10 o'clock hour. It's time for Pro Bono Chambers on this beautiful, cold, cozy Wednesday morning. My name is Ruth Usman, and as always, I'm here with our in-house barrister, Uche.
Good morning, Ruth.
All right. And yes, we also have a guest, Barrister Tony Ekoba. Did I get it right?
Yeah, you got it right. Good morning.
All right. So you're both welcome to Pro Bono Chambers this morning.
Thank you.
Thank you very much.
Uche is looking excited. Is there something you want to share with us before we start Pro Bono proper? Any story you want to tell us about? Anything about the law? Something interesting?
No, not really. Not today.
Oh, not today.
Some other time.
Okay, we'll hold you to this. She made a promise just now that she will tell us something interesting. All right, today we begin with our focus, which is all about wheels. Not the wheels of a car or anything like that, but WILLS.
Yes.
Wheels. All right, wheels in Nigeria. Of course, we want to know exactly what a wheel is and every other thing, as long as our time can permit, and every other thing about that. We will be talking about that today on the program. So let's begin by having some insight into what really a wheel is.
Okay, before we delve into wheels proper, I would like to ask you, Ruth, do you have a wheel?
Are you wishing me dead?
That was the exact response I wanted you to. I was hoping I was going to get.
You got it.
And that's quite it's quite common. It's a very common response there. You know, when you mention wheels, people think you're wishing them dead, or that you're trying to, there's this remembrance of your mortality and the fact that Sunday somehow we're going to leave this fair and it's going to be all over, you know, and that's why a lot of people don't want to avert their mind to issues of wills, or they don't want to talk about wills in the first place because it's not so pleasant a topic for them. But it's very important, and we hope that by the end of this discourse this morning we would have shown and exposed how important it is to have a proper will during your lifetime, because of the many advantages a will has.
Okay.
Yeah, I actually saw the expression on your face when that question was asked, and it showed how you felt and how, as she stated, as Uche said it, how a lot of Nigerians feel whenever a will is mentioned. It's a great thing to have a will. It doesn't mean you are about dying, or you're about to die, or you're dying immediately. It just shows that you are taking the right step to ensure that things are done well when you live. We all should be planning, hoping, and trusting that one day we are going to be with the Lord. So it's a good thing you make a will so that your property will be handled the way it should be handled. Some things you left behind, there won't be problem amongst your relatives or your siblings or those you're leaving behind, whoever it is. So it's a good thing to make a will. We're going to state a couple of the advantages that making a will actually has. So we'll state in the course of this program. Thank you.
All right. So I think we should just know, if we're talking about a will, what does it involve? What is contained in a will?
Okay, a will is a testamentary instrument that is voluntarily made, that is executed in line with the law as it should be executed, depending on the type of will it is, and also states how the person who is dying, sorry, who is making the will,
You see?
who's making the will, the testator, if for instance, if it's a man, or testatrix, if it's a woman, wants his or her property to be shared or to be deposed when he or she is no more. So that's what a will is, like saying, this is my wish, how I want my things to be done, or my properties to be shared, or how I want this and this to be done. It might not necessarily be about sharing property.
Yeah, I wanted to ask, because what if you don't really have any serious property you want to leave for another person or a group of people?
There must be at least one gift in a will. That is one of the conditions of a valid will. There must be at least one gift, but then there could be other instructions. Okay. It could be about how you want one of your children to be taken care of. You could appoint a guardian for your child, for instance. You could give instruction as to how you want to be buried. You could give instruction of how you want something to be handled. But at least there must be
so even if it's just your clothes.
Yeah, even if it's just your clothes, yes.
Okay, I want all my clothes to go to this person or to charity.
Exactly.
Interesting. So it covers everything, both instructions and physical, tangible stuff.
Very well, it does.
And I must say that a will is testamentary in that it only gains life after the maker is dead. So for as long as the maker of a will is alive, the will lies dormant for that period. Now it comes into effect, let me say so, not resurrect now. It comes into effect at the passing on of its maker.
So if I am writing a will now and I have 2 children, and then before I die, just one of them just gets this is my mother's will. I need to have my share of. Can't you see what she said? She belonged to me. I want it now.
No, it doesn't work like that. It would only take effect. The provisions in a will and the wishes of the testator in a will will only take effect at the demise of that person, and not while he or she is still alive.
Okay, so what happens, for instance, someone who does have a lot of property, but unfortunately this person is not married yet.
Okay.
But then this person decides to write a will. After some time, you get married, you have children, you have a wife or you have a husband now, and then you have children, and you've already written your will while you were single. Is there any room for you to make adjustments or to amend this?
Yes, there are rooms for you to make adjustments. Any will that was made before the person married becomes void. You need to make another will. Marriage is one of the things that void, one of the conditions, or one of the things that voids a will. Like you need to make another will to cover the fact that you're married. You need to establish, reveal the fact that you're married, and also be able to cover your new status. You understand? Because you're expected to have certain provision in your will that will take care of your wife, your spouse, for instance, and then maybe your children if you have kids. So that's very, very important before or in the process of making it. So you need to know that if you made a will before you married, you need to make another will. Yeah, and also there's something called codicil. It's a process of amending or maybe adding adjustment to a will you made earlier. You could make a will and decide to make a codicil. The codicil is just another addition to an existing will.
Okay.
So that's...
Oh, an addition to an existing...
Yes.
will.
So if, for instance, you made a will in 2014 and by 2016 you acquired a property or a new house or something else, a new house or a land or something, and you want to include that in your will to be covered in your will, instead of changing the entire will, instead of redoing the will in its entirety, you could just use a codicil to include that into the will. The codicil is that vehicle through which a will is either amended or altered.
And it also has the same features, the same requirements of a will the fact that it has to be signed, it would state some of these requirements.
Yes, we need to know that the entire process, what it takes for it to really make any sense, to be valid and all of that. What do you need? Who needs to be there? Do you even need to have a witness? Do you need an advisor to do that? I mean, it may be your personal property and all and everything, but do you need any legal representative? Who do you really need to do?
Very well. We are going to give these requirements mostly with respect to statutory wills, because there are different type of wills. There is statutory will, there is non-cooperative will, and there is will that they have for seamen and other people who don't have that chance to write, to like sit down and write a documented will. So
okay, like those who've not gone to school.
No, not necessarily. There are different kinds of wills, but we have what we call a privilege. Now, a will has various requirements for it to be valid, and one of such requirements is that it must be in writing, and that it must be made by someone who is of a legal age, that's 18. And then it must be witnessed and all of those. Now, but for some persons, like what we call the privilege will, mostly used by people at sea, seamen and people pilots, in the armed forces. Yes, yeah. Those persons, because of the nature of their job, how very risky their jobs can be, their wills might not necessarily follow this stipulated patterns, this stipulated requirements. So it's permitted if their will is not in writing, if their will is not witnessed, and if they are not even up to 18.
Yeah, they don't have to be of age. They could be they are less than the required. The law as it is, the Wills Act, Amendment Act of 1852, which is what we are using presently, stipulates that the minimum age requirement for you to be capable to make a will is 21 years. Though there are various will laws of various states, like Lagos has their own wills law, which stipulates 18. So for this privilege wills, you don't necessarily have to be of that age to make the will. You once it's that some of these conditions,
once you fall in that category of
having to work in such place, or being with the armed forces, or being maybe a pilot, or being a seaman, you have this privilege of
I don't know
making.
about who perhaps might have been or could be the youngest pilot, but can we have someone to be a professional pilot at perhaps 15 years of age? And can anyone join the military before they are 18?
Yes, I think so. I think in some situations where a country is at war, they conscript
child soldiers,
not child soldiers, able-bodied young men who.
Up to 18. I mean, that's like the legal age we're talking about here. That's why I'm really asking, because
and then some persons can walk, probably even, especially maybe if they are apprentices, they work before the age of 18. And so if, for instance, you're an apprentice in certain conditions, especially where your job has to do with you working at sea or something, I'm sure that you are covered under that.
Don't forget the fact that this law is one of the borough's laws. It's under SOGA, Statute of General Application. The Wills Act, as it is, was actually one of the laws in the UK, in the United Kingdom. So it's one of the things we inherited. So it wasn't just about what is applicable here. It was also about what is applicable there, which we adopted.
Let's just have this clearly stated. How many types, like just by number? Now, how many types of wills do we have?
There are majorly 3 types of will.
Okay, they are.
And there is statutory will, which is provided by the statute law. You have the Wills Act, you have the Wills law, and then other laws different states make with respect to will. There is non-cooperative will, which it's mostly written. It's not written, but it has certain requirements. There has to be 2 witnesses. It has to specify the property and also specify the beneficiaries. You understand? Then there is privilege will, which we already discussed just now, which is about those who are with the armed forces or seamen and all that. So there are majorly 3 types of wills.
Is there any of these that is like the common, we can say like most common type of will that many people just adopt?
Yeah, the statutory will. It's the most common.
Okay.
If you're married under the Marriage Act, you are you have to make a statutory will. you're expected to make a strategy will if you're married under the Marriage Act.
Okay, so let's focus on that for some time now. Normally, just normal family, you're married, you have a wife, kids, and all of that, you have property and everything. Landed property, money stashed somewhere, other things. So what was the process now of you writing that will? What does it involve?
Yeah, first of all, there are, as Uche stated, there are requirements every will must have, a statutory will in this sense. Those requirements are stipulated by law, and they are what make the will valid. Without such conditions, the will cannot be seen as being valid. One, the will has to be written. Now, there are two ways to it. You could make a will by yourself. You could write the will yourself. You could also have your lawyer write the will. You could write the will in your own handwriting without having it typed. You could also have the lawyer write the will as in typed. But if you are to have a lawyer do that for you, it has to be by your instruction. You have to instruct the lawyer as to what should be written. And then after the will has been written, it comes down to the signing process. A will can be signed in three ways. You can sign the will yourself in the presence of two witnesses.
Who could be who and who?
Yeah, who could be? No, the witnesses have to be of capacity also. They have to be people who are of age, who don't
legal
have
age.
Legal age. You also have mental capacity, who understand what they are signing, what they are attesting to. You understand?
And they must not be beneficiaries.
I wanted to ask that.
Coming to that. So they must not be
beneficiaries in the will.
Why is that so?
Well, I think that's one of the mechanisms the law puts in place to avoid fraud, to avoid a situation whereby you have someone who is a beneficiary and then one way or the other tries to influence his gift, so to say, what comes to me.
Like I'm a daddy's girl, and then I just go close.
And then you now say, please sign. Okay, daddy, please do this one. Please sign this. Okay, no, daddy, do it. No, that shouldn't be.
Wow.
That is not permitted.
Okay.
And then the person making the will must be of a sound mind.
Yeah.
Then he must be aware of the contents of the will.
Yeah.
The contents of the will must be within his knowledge. It must not be something he's not aware of. He must know what is in there,
of the gift,
and then what goes to who, and all of that.
So if you have an aging parent that perhaps already has dementia,
yes,
that person, whatever is reading, whether there is a lawyer or the document should not be trusted because the state of mind is a bit shaky already.
If at the time he wrote the will or she wrote the will, she was of mental capacity, because the law looks at when the will was written and when it was signed. If at the time the instruction was given, he was of mental capacity, and at the time it was being signed, with the witnesses being around, it was mental. It could be seen as, or it should be considered that the will be invalid. The law looks at the capacity with respect to the person. Does he know? Does he understand what he's doing? Does he understand the extent of the gift being given, or the gift being given? Does he understand to whom it is being given? So these are some of the conditions that the law stipulates as to the capacity of the person making the will. So if these things are met, then it should be seen that the will is valid.
Okay. We will continue the conversation on wills in Nigeria in just a moment. Do stay with us. We'll go on a quick commercial break and we'll be right back.
Beyond Radio 101.1 Rights Radio.
I know you're gonna dig this.
Redefining broadcasting.
This is to inform the general public that the activities of scavengers, also known as Babambola, is prohibited within the Federal Capital City. Their activities are henceforth restricted to the area councils. Residents of the Federal Capital City are advised to be vigilant and report any suspicious activities to law enforcement agencies. Together, we can make Abuja the city of our dreams.
Beyond Radio 101.1 Rights Radio.
I know you're gonna dig this.
Redefining broadcasting.
Èyí ni láti kéde pé ojúṣe àwọn ìságolo sapáànù tí a mọ̀ sí Babambola ti dókun nílùú Àbújá àti ìjọba àbílẹ̀ mẹ́fẹ̀ẹ̀fà bí ọwọ́ sìnkú àwọn agbófinró bá wá bá ẹnikẹ́ni nínú wọn yóò fi ojú ba ilé ẹjọ́ o ẹ̀yin olùgbé àbújá ẹ yára tètè tẹ́tí lẹ́kọ̀ọ́ tẹ́ ẹ bá rí ẹnikẹ́ni tí ń yọ́lẹ̀ ẹ̀dà tí kò tẹ̀lé òfin tó sì ń sagolo tí ń sapáànù ẹ tètè fi tó àwọn agbófinró létí àjọṣe wa ni o láti mú kí olú ìlú yìí dùn ún wò kí ó sì dùn ún gbé pẹ̀lú ìrọ̀rùn ìkéde yìí wá láti iléeṣẹ́ ìjọba olú ìlú yìí ìyẹn Federal Capital Territory Administration.
Aridna akugna aza vien kinzin nege tuntun aza mbatun aya una vidankulu na kobege baba bola atela jebaje o kinzin ne nkoyin tinya kola ka hae baba tuntun kola pojin nara kansi vien ba logutna e kinzin ne ozana wa sasatu vidankulu wotna aba wa api aga otata agna kinzin dalo mbasaselo ge balaweka na zaipia da na azalaba saselo kinzinege balawepi na ja zaipia bakara na bana banwa ba tabashiba agaba tata yudna wode ya mi kinzinne ko na ba agba abeji awudneba mbagbin FCT atutnu jina pokoge Federal Capital Territory Administration.
Udummiri ebidola a na-adọ ọhaneze aka na ntị ka ha gbochie ma kwụsị akparamagwa ga-ebute mmiri ọdụdọ na mbuze dịka iwufu ahịhịa n'ime mmiri na-asọ asọ ya na ịtụnye ihe n'ime gota. A na-emekwa ka ị mara na iwu ụlọ n'ebe na-ekwesịghị dịka ụzọ mmiri nwere ike ịkpata ịtụfu ndụ ndị mmadụ n'efu ya na ihe nweta ndị mmadụ ịla n'iyi mee ihe kwesịrị dị mma. Ọ bụ Federal Capital Territory Administration FCTA na-ezitara gị ozi a.
A yayin da damuna ta fara kankama, an shawarci al'umma da su guji bata muhalli wanda ke iya jawo ambaliya. Zub da shara ba kan gado shine makasudin babbar ambaliya a birnin tarayya Abuja. Saboda haka kar ku zub da sharar ku a magudanan ruwa. Bugu da kari, an shawarci al'umma da su kiyaye yin gine-ginen gidaje a hanyoyin ruwa wanda yin haka kan iya jawo rusan da zai laƙume rayukan al'umma da dukiyoyinsu a lokacin damuna. A koda yaushe ku kasance mai yin abin da yake daidai. Wannan sako na zo muku ne daga hukumar birnin tarayya FCTA.
Wani ya samu wani yana
gẹ́gẹ́ bí a ti mọ̀ wípé àsìkò òjò la wà èyí ni láti sọ fún gbogbo ènìyàn láti yàgò fún ìwà ìdọ̀tí dídà ìdọ̀tí síbi tí ò bójúmu tí ó lè fa omíyalé àgbàrá ya ṣọ́ọ̀bù dídà ìdọ̀tí síbi tí ò bójúmu tàbí òpópónà sì jẹ́ ohun kan gbòógì tí ó ń ṣokùnfà omíyalé àgbàrá ya ṣọ́ọ̀bù ní ìlú Àbújá. Ẹ má ṣe da ìdọ̀tí sínú gọ́tà tàbí ọ̀nà tí ìjọba ti pèsè sílẹ̀ fún omi láti gbà kọjá. A tún fi àsìkò yìí sọ fún gbogbo olùgbé FCT Àbújá láti rí dájú wípé wọn ò kọ́ ilé sí ọ̀nà tí omi ń gbà kọjá. Èyí lè ṣe okùnfà pípàdánù ọ̀gọ̀rọ̀ ẹ̀mí tàbí pípàdánù ohun ìní ní àsìkò òjò. Ẹ ṣe ohun tó tọ́. Ìkéde yìí wá láti àjọ FCTA Federal Capital Territory Administration.
As the rainy season begins, the general public is hereby advised to avoid environmental practices that could cause flooding. Indiscriminate waste disposal has remained a major factor causing flooding in the FCT. Do not throw your garbage into gutters and drainages along waterways. Residents are also advised to avoid building houses around natural waterways, as this could also lead to loss of lives and property during the rainy season. Do the right thing. This message is from the Federal Capital Territory, FCTA.
Human Rights Radio on 101.1 FM.
Join our diverse team of legal experts as we provide education and guidance to you, our listeners, on a broad array of issues raised by the modern legal landscape, absolutely free on Probono Chambers, airing on Human Rights Radio 101.1 FM, redefining broadcasting.
Human Rights Radio.
It's 10:30 a.m. Thank you for staying with us. Probono Chambers continues. I've been speaking with Barrister Uche and Barrister Tony this morning on the program, and we're taking a look at wills. And before we went on that, we were talking about entire process, what it takes for a will to be valid. Yeah, things that should be done must be done. All right, so we will continue on that.
Okay, I was explaining about the fact that you can make your will yourself. You can also ask your lawyer to type the will, and then the signing process, then it's required after the will is written.
Okay, sorry. Do you require the lawyer to be there when you're writing it, or you can just write it on your own and then later on invite the lawyer to go through with you? Yeah, the lawyer could be there, but the law doesn't specifically put so much weight on the lawyer being there or not. Who the court really required to be there are the witnesses. There must be at least 2 witnesses who must be there at the time that you are signing it. And you said they must not be any of the beneficiaries.
They mustn't be different, to avoid fraud or undue influence, and all that. So you signed in the presence of the 2 witnesses who could sign, not in the presence of each other, but the both of them must be there when you are signing to show that they attest to the will.
Okay.
So after this will is signed, you now keep the custody of the will. The custody of the will could be, you could keep it in the safe in your house. You could keep it in the bank. It could be kept at the probate. It could be kept just anywhere safe, because it's not a document that takes effect, as we just stated, from that point of signing. It's not inter vivos, as the law says, as they say in law. Like, it doesn't take effect immediately. It's something that takes effect after the person has passed away. So you keep it for safe custody. It's important you keep it for safe custody to avoid it being doctored, or to avoid it being damaged, or to avoid someone trying to tamper with it or what is inside it. It's just a document. So you envelope it and then you keep it in safe custody. You could keep it with your lawyer. So then when the person dies, or after the person is dead, the lawyer would take the required process to read the will, which will get to state here afterwards. So you get to read the will. The lawyer gets to read the will. They open the will first, and then get to read the will as is required by law. So these are just like explanatory ways that wills are made.
So, if you have, let's say, 4 children, for instance, you have to specifically mention their names and say this particular thing should go to Ruth, this should go to the other person, or you just say, okay, this property that I have, I want it to go to my children, without being specific about their names.
Yeah, you have to be there. First of all, these are gifts. They are called gifts, and the gifts are legacies and devices. Devices are the ones that are properties. Legacies are chattels, personal things like clothing, money, and other. So you have to specifically state which one is going to who. There are general gifts you could give general to all your kids. It could be a house you say, okay, all of them will benefit from. Maybe at the end of the year, whenever salary or whenever rent is paid by the tenant, that everybody should share out of that. Could be a general gift. But you can also have specific gifts that you say, okay, this person takes this person takes this person takes it. So these are some of the things that a lawyer will have to guide you. That's why it's important to have a lawyer guide you through, because without a lawyer guidance, you might make a will that doesn't really specify what the law requires. Even with respect to signing, you're expected to sign at the foot of the will to ensure that what where the signature is covers all that the gift. So if you don't sign at the foot, you sign at the middle and then go to write another gift, another thing below where you signed, whatever you wrote below is considered invalid.
Wow. All right. Now, I'm sure people listening would want to know, why is it important to take the time while you're still alive, strong and healthy, and maybe even young, to start thinking of things you want to pass on to people you may leave behind? Because you never can tell who will die first. Why is it important to write a will?
Okay, before my colleague takes that on, I want to state that we have so many cases, a litany of cases in court that are there over whose subject matter is the disposition of property. Now, and these cases are there for years. They linger on for as long as 30 years.
Wow.
And so you can imagine a family going back and forth over that. And one thing is, someone said before that once a matter ends up in court, the parties are not friends, and to a large extent it's true. So instead of creating this divide rather in the family, it's very important. A will protects the family and your dependents and the people you leave behind from going through this road, traveling this road. It helps the testator now to determine exactly how the testator is the maker of the will. The testator is a person who made the will, the owner of the property and all. Now, it helps him, it gives him the leverage to determine exactly how his property will be disposed of at the point of his passing on. Now, it's important because it helps you to properly decide for yourself what goes to who. So your property that you've labored for does not end up in the wrong hands. And then you have cases where children and dependents begin to suffer at the demise of probably their breadwinner because there was no will to properly state. So this thing prevents, apart from the fact that most night, especially in this part of the world, when you mention a will, the person just feels that no, this person doesn't wish me well. But then the long-term advantages outweigh whatever emotions you have about a will. It protects the testator from the family, in fact, from a lot of battles and hassles, a lot of rancor, a lot of fights and quarrels and all of that, because like where we come from, these things people attach a lot of meanings to the properties of probably their fathers and breadwinners and mothers and whoever. Now when there is no will, many of the times it doesn't end well. So it's always important so that you are able to better secure the future of your children and your dependents and whoever it is you may wish to be a beneficiary to your estate. It's better. It helps to protect the interest of those people.
Very well. Very well. Yeah. Just to add to what she said, it will afford you the opportunity to appoint a guardian, just as she stated, for your underage, for instance, underage children. So you can appoint a guardian to say, okay, so amount of money should be earmarked for the training of my children until they reach so age, or maybe until they are done with university. You can state that in your will.
Yeah, like sorry to cut in some movies, you just see that maybe they take someone to perhaps grandparents. In some cases it happens like that. You see, the grandparents are the ones that will take care of the grandchildren if their own parents have died, and then they say, well, your parents, the directive they left behind was that we would hand you this money or this asset or anything when you are so age.
Exactly.
Kind of.
Exactly.
Okay.
So you can do that in a will. You can do that in your will, and then it protects your children. You understand? That is one, just as she stated, one of the advantages. Another advantage is it's actually cheaper to have a will than not to have a will. It's cheaper because it's more cost effective to have a will. It just a testator or a testatrix, if it's a woman. If it's a man, is a testator. If it's a female, is testatrix, the maker of the will. Could make a will, and then you don't need to have once the will is made and the person dies, immediately it takes effect.
Yeah, how much time do you need to allow pass before you start talking about wills?
The person has to be buried, first of all.
Okay.
It's important you let the person rest before you start talking about that. The person has to be buried, and then also you have to also get to the probate.
No, even if the person is not buried, because sometimes some people state the way they wish to be buried.
Yes.
And where they wish to be buried. So sometimes it's also important for once a reasonable time, yes, you can now proceed. Once a reasonable time has...
It can be opened, at least just in case.
Yes.
There is such thing as this is how I want and where I want to be buried.
Yeah, the person can give instruction of how he wants to be buried in the will. It could be stated in the will.
So let's say it is open and you check that. Now, can the lawyer, for instance, maybe and or the witnesses now open and say, okay, but they should already know. I mean, do you understand? They should have known that, okay, there was a directive on the burial.
Yes,
the lawyer could know. That's why it's usually important to have your lawyer go through that with you, because the lawyer knows, but the lawyer is not supposed to reveal any of the content to anybody. It's supposed to be just between. It's a privileged,
I'm thinking about a
privileged
situation
communication.
like this now. If for instance they are yet to bury the person, but then they now opened it up to say, okay, let's see if there are any directives on how to bury him, and then they read everything through, and perhaps one of the children, Ruth, I see something, and I'm like, no, Daddy could not have given me this, and then I start making trouble, and Daddy's not even buried yet, you know.
That's actually one of the reasons usually wills are read after the person is, but that's actually the most common practice.
Okay.
It's usually read after the person has been buried. That's when the family gathers, they give information to everybody, and then they read the will as according to the law. So that is one of the things. Then you also look at the fact that the will, as it is, we didn't point this out, but it's important to point it out. The fact that an illiterate can make a will. You don't necessarily have to be very educated. An illiterate can make a will, just that an illiterate juror.
So if you can't read and write English, you can give that directive, and people just write just accordingly.
Exactly.
You
You just make your mark or your sign. You know, a blind person can make a will. You know, a blind person can make a will. Someone who is deaf and dumb can also make a will. It's just that jurors have to be there. A blind person can make a will, but a blind person cannot attest. You know, a blind person can make a will, but a blind person cannot attest. So, but in those these kind of wills, you just have to put a jurat stating that the content has been read to the person, what the person is signing or appending his mark on has been read to the person and is well understood by the person. Has been read in the language or read and translated in the language the person understands, and then is well understood before the person makes his mark or puts his signature on it. You know, so this, as we stated, this is one other advantage. This is one other advantage of making a will. So then, a will also, it's something that helps you to be able to, you know, just as we stated, rest in peace. That your family, they will know, whoever knows, you know what you gave to this person, you know what you gave to this person, you know what you gave, you know how your property is shared. You can as well give your property to charity if you make a will. You know, if you make a will, you could decide to give part of your property to charity, and nobody would contest that.
What if the person decides to give everything to charity and the family is there?
No,
can they contest?
Yes,
is it possible for, you know, if I feel like, no, I don't agree with this, can I?
If there is any suspicion in the will, if a will is read and it's saying that there is a suspicion of the person not
whether
being,
it is suspicion or I am just not, I don't feel satisfied that my parents left this for me.
Not about you. There are some things, not about the beneficiary here, not about one beneficiary, but there are some things that are considered generally the relatives. Everybody look at that. There's no how this man could have willed everything when he has these kids.
No, but this is what I'm saying, that he actually willed things to everybody, the beneficiary.
But you're not satisfied by the gift that comes to you.
I am not satisfied. Is it something, can I take it to court?
Yeah, it can be contested. The will can be contested.
So what can be done?
No, but you contest the validity of the will.
Okay, that's
yes, that's what you can contest. Now, it doesn't matter if he gives you one pair of shoes or he gives you a house. What the court will look at is, at the point where he was giving you, was he in his right frame of mind? Was the entirety of the will valid, or has it been tampered with? Is there any suspicion of fraud? Or maybe or undue influence, as when he was, maybe somebody came and said, no, sorry, Daddy, no, don't give this to this person. No, the one of the other requirements of a will is that it should be made voluntarily. The person making it should be free from every external influences. So it's not about what he gives to you now. So long as it is established that the will is valid and it meets all the necessary requirements, then it doesn't matter what goes to who.
And then while they are reading it, that's when you realize that your parents had another child you never knew about, and he was included in it, and he had his own share.
Yeah, of course. Of course.
Yeah. You never knew you had a half brother or sister.
Oh, well, it's a good revelation. It keeps the family together.
Oh my goodness. All right, let's listen to our listeners. 081-8999-1011. If you have any questions, please call in. Let's hear you. If you have questions pertaining to other legal matter issues that may not have anything to do with our conversation, you're so welcome to call in, because this is Probono Chambers, and the barristers and I on the other side, we are all here for you. Hello?
Hello, good morning.
Yes, morning. You're welcome.
My name is Evangelist Ongwe Daniel Garba. I'm calling you from Garkina.
Okay, please go ahead.
I'm interested in this will issue. So there are certain questions I would like to ask. The will, if you're doing will, who knows about your will? That is in your family, for example. If I'm doing a will now, who is opportune? Is it between you, the person doing the will, that is the owner of the property, and the lawyer, or your wife? Or I want to even say, is your wife permitted to know about the will, or is between you who is doing the will and the lawyer? And if it is you who is doing the will, between you who is doing the will and the lawyer alone, you know, in this world, you can never tell if another member of your family is not aware of. You can never tell. A lawyer who is also has some questionable character or something, or whom you may not know that has any issues about his character or her character, you might go and do some things, or maybe when the person is dead, you can go and change some things, and then maybe to somebody can influence it. So
in fact, I get your question. So you want to know if you should have a backup, someone you perhaps can trust in your family.
And particularly, I want to know, is your wife, can you let your wife know if your wife is part of the will? Because it's possible that I can put my wife there. Thank you very much, Evangelist Ongwe.
All right, thank you.
Yeah, you can let your wife know, but importantly, you should let your lawyer know.
His concern here is the lawyer. He is not a part of his family. He's not a member of his family. Now, if there is no other person in his own family that knows about this, the lawyer on his own can decide to doctor this, and no other person will know. How do you protect that, yourself from allowing that to happen?
Now, that's why it's important that you keep the will safely. The will must not necessarily be one copy. You can have it in copies and keep them safely.
If they're in multiple copies, won't that be very suspicious?
No.
And they mustn't be with a lawyer too.
It could be in the bank. It could be in the probate office, probate registry rather. Then it could be, you could have one copy safely kept away, and then you could keep one with maybe your lawyer too. So that you could have 4 copies scattered around.
If this person in question now is like this caller who is uncertain about the lawyer, I am thinking it may just be better not to keep.
Now we also have what we call the executors. Now we didn't mention that, but these are people that you are appointed, that are appointed by you in the will. You mentioned them in the will as people who will administer the estate, and execute your wishes, because the will cannot.
Family members.
They could be anybody. But people integrity that you trust, or people that you that have exhibited some form of integrity, and people whom you are comfortable with. They are people you could appoint as executors of your will.
That would also be in the will.
Yes. And then you could also tell them, it's possible you could tell them that you are going to be executors of my will after my demise. So these people know. The will might not necessarily be in their custody, but they are aware that there is a will somewhere, and that someday that will come out in administering your estate. Now, your witnesses too might not necessarily know the content of your will. It's not important that they know what is contained in your will. What is important is that they are two, and that they sign, and that they were there when you signed. Now, they can also sign in the presence of each other or not. But it's important that they were there when you signed, and that it doesn't matter if they know the contents of your will. Yes.
Okay. Interesting. I do hope you've answered his question. 08189991011. But then again, I'm thinking, what if your executors die before you?
Yeah, that's one advantage of a will. Different from where that is tested and intestate. Tested is when you made a will. Intestate is when you didn't make a will. Now, when you make a will, where your executors die, if you can appoint more than one executor. Yeah, can appoint more than one executor. So if one executor dies, the next executor can actually take up from what the executor is supposed to do. So, and the other executor dies, then you can also have. And then the executors of the executor, for instance.
What's that again?
Yeah, the executors of the executor could also be, if that is stated in your will, you could also state that if, for instance, you have an executor and you believe the person who you are appointing as executor has executor, you could also state for the executors of it. It's one advantage of having a will. It's one of the things that could make
like
it
a third party.
Yeah, more like it. But it's something it doesn't actually usually arise, because most of the times you have more than one executor. So usually you should have. So if, for instance, one executor dies, there's a likelihood that
the other would.
Yeah. So if you have 4 executors, there's no how all of the 4 executors would die at the same time. So,
okay. I was just thinking of something, but it's all right. Well, let's see if we can get one other call before we call it a wrap on the program. Hello.
Hello, good morning.
Good morning, welcome. What's your name?
My name is James. I'm calling from Bwari.
Okay, please go ahead with your question.
Please, I want to know, during the process of taking down, writing your will, is it accepted to also do video or probably a voice recording?
Okay. All right. I'll allow the barristers to answer that.
Yeah, you can do a video. You could do a video. You could actually talk to your family. And it's recorded. They could play that at the point of reading the will, but that doesn't still take away the place of a will. A will is a written document. It is not a video. A written document that is signed.
But it is you that are seeing the words are coming out from your mouth. You don't appear to be under duress in any way, and anything you've given instructions. Yeah. Can't it work?
A video cannot take the place of a will because it requires your signature. You can't sign a video.
What is more convincing than you see someone saying words, speaking by himself? Yeah. Will that, signing on a piece of paper and you actually saying the words yourself and you're caught on camera?
I understand how that is.
Okay.
What the people usually do is that they could do a video while the man is signing. You could do a video where you could read out what you have, and you're being recorded. Okay. You sign, and then your witnesses sign. Or you could just sign. It shows that you actually performing an act, which is signing your will. You understand? And then after that, you talk to your family. You greet maybe your wife or your kids, and then talk to them like as if you were alive.
Or you can have someone emceeing for you in the background and say, "This is Mr. This signing."
I've seen a will.
You've seen a will. That is, you're not supposed to get a crowd when you are doing. Signing your will. Not everybody's supposed to know the content. Just a few, maybe your lawyer and your lawyer doesn't necessarily need to know the content.
Commentator. Not that. Perhaps MC is very elaborate. Okay, that's the much we can take though on any further information generally on what we've talked about so far.
Well, we didn't talk. The topic of wills is a very elaborate one. What we did today was just to give the basic background of a will. We have not talked about how the will, how you obtain probate, how the executors begin to act, what happens when a person dies intestate, and how his estate is administered, and all of that. But our final thought on this is that, on this matter.
For today. for what we covered today.
Yeah. Okay. For this moment, we want to say that it's very important. It's very important. Like my colleague said, it's less expensive to have a will than not to have one. It's not proper for persons to die and leave their families open to attacks, to all form of attack. Anybody can just arise from anywhere and claim anything. To be able to avoid such occurrences, it's always important that you put the mechanisms in place where your wishes are carried out and your estate is properly handled.
Obviously, even Barrister Uche does not want to die. She didn't want to say her final thoughts.
Yeah. I wouldn't want to die this morning.
Yeah, just she wouldn't want to die now, but if it's about making will, I don't know. She might have her will already made. So it's.
Am I included in your will? You've not known me for so long, but at least.
Yes, you are. I willed a pair of shoes.
I love shoes.
So on a final note, I will tell Nigerians to go out there, make their will. Try and make your will. It's important you do that. You are just as my colleague stated. You set things right. After you've left, you ensure that things are done the way they should, and then you have your little kids being taken care of when you've gone. So it's important you don't look at it as if you're wishing yourself somebody's wishing you dead immediately. It shouldn't be considered that way.
All right, thank you very much, Barrister Uche Anthony, for being here.
Thank you
very much,
and thanks to our listeners and callers as well. My name is Ruth Usman, and I will see you in the 11 o'clock hour on Media Lab.
Join our diverse team of legal experts as we provide